suppose they did come out and say, no, that's unconstitutional, or like what impact would that have? Would that change a lot of what's currently being done?
There are three things they might do. I mean, obviously they could just uphold the law, but assuming they didn't, there are three versions of this. One is to say, we, the court, think there's something uniquely problematic about this specific rule, and so we're going to strike it down. But as to other rules like it in the international tax area, and as to other rules like it more generally, we think those work. And interestingly, in the cert petition, the moment when the taxpayer was asking to litigate this case, the claim was that this was a very broad issue and it applied to a lot of things. But by the time the taxpayers wrote their brief for the court at a later stage, they've switched to say, actually, most things under the law are okay, just not this. And I have a feeling that tactically they're thinking the court would be more reluctant to do something that it thinks has sweeping implications. So they could just strike down this particular rule. That's still about a $300 billion issue for the US government, because there are a lot of multinationals that paid this tax that could then ask for a refund. But it's still limited in that way. The broader version is for the court to say, look, we're not comfortable with the idea of taxing shareholders on the corporate's gain in this international context and also in the domestic context. And that would strike down a bunch of rules. And that's more like $1 trillion issue. But then there's a third possibility, which is they could go much broader and say, don't tax people until they have the cash. And I'll just mention that that's a bigger deal. So sometimes we buy a bond and we pay $90 for it, and it grows to $100. And instead of waiting until the maturity of the bond for the $10, we have to pay tax on it. This is so-called original issue discount, or OID. And that's been the rule for many years, but it isn't consistent with the idea of only taxing people when they've sold. So in theory, the court could say that's not okay. Same deal with some, accrual accounting. There are businesses that pay tax based on what they're entitled to get, even if they haven't gotten the cash yet. Well, strictly speaking, that's not really consistent with this idea of a realization. If what the court says suggests that that's not okay, most of the business world in the United States follows that rule now. It could change. So we can speculate about how broad this is. I'm pretty sure in this decision, they won't go broad. But depending upon what they say, there could be more cases. And over time, more and more of the rules that we take for granted now could be changed. It's not what I predict, but in theory, it could happen.
Wow, yeah, that accrual accounting, I didn't even think of that. So it's strictly like a company does some work for a client, and then they have like accounts payable has gone up, accounts receivable from the corpus thing has gone up, and technically, a lot of the accounting would show that as net income for that period, and you pay your tax on that. But strictly speaking, the money didn't come in the door yet.
Right.
Okay. All
right. When really, Bob, I mention this because I think part of the reason the court is going to be careful not to say something imprecise and too broad is that enough of the briefs are pointing out this kind of issue that they're going to think, they might just think, well, actually, we think the tax is fine. But the other thing they might think is, no, we think this tax is not okay, but we want to be sure that it's not okay for reasons that are pretty limited and that don't apply to all this other stuff. And so my guess is we're going to get either this thing upheld or struck down in a fairly narrow theory.
Okay, and so that's part of the function of the amicus briefs is that, at least in theory, their staffers should all be reading that stuff and then letting them know, hey, we haven't thought of this. Like, make sure you keep this in mind when you're writing your decision or your opinion.
Because remember, the Supreme Court, they're not Congress. They don't have committees with tax experts and their staff. It's not what they're supposed to do. It's not what they do.
Right.
So therefore, it's helpful to them to try to give them details that are not in the case itself, but could be affected by the case.
Right. Okay, well.
Hey, everybody, this is Bob Murphy. Thanks for listening to this clip from the Infi podcast. If you like what you heard and want to hear more, please consider subscribing and share this video with others. We've got new episodes dropping every Friday with more insightful discussions. Stay tuned.